Hi, Huntington Beach. Michael Gates here with a couple important updates from the City Attorney's Office. A couple important legal matters. First, the fight against high-density housing, as you know. Last year, we filed a case in federal court challenging the state's high-density RHNA laws as they apply to Huntington Beach. The next hearing on that case is in the Ninth Circuit this October. I'll be arguing. We will keep you updated on that case, but it looks very good for Huntington Beach in federal court. Also, as you know, last year in March of 2023, the state sued Huntington Beach for not having adopted its housing element. And that's because the state mandated essentially a poison pill, 13,368 units of RHNA for Huntington Beach, which, as you know, translates to 41,000 high-density units in Huntington Beach, which translates to a 50% increase in the city's housing stock just in the next few years. So that's essentially the poison pill, made it impossible for the city council to adopt because of the harm that it presented to the environment. The state sued Huntington Beach last year. What it sought was immediate relief, basically a swift trial in 120 days and then the adoption of the housing element with that poison pill within 120 days. We've been fighting that case in court every day for the past year. So clearly, the state didn't get what it wanted initially because now it's been well over a year since the state originally filed its lawsuit. More than that, the court just came down with an order recognizing that the city of Huntington Beach does not have an updated housing element. But when it reviewed the proposed order from the trial from the state, the court made some really important changes to that order. It struck a number of things, including the court struck the 120-day timeline to adopt the housing element. So there's no 120-day timeline anymore. In fact, the state's interpreted that to mean that the city has up to a year to adopt a housing element. So plenty of time there on that issue. The other important thing is that the previous order ordering temporary relief and preliminary injunction, that now has ended because that order was the previous order. It's now been superseded by the current order. The current order also, on that order, the court struck all of the penalties. So you've heard a lot of people talk about all the millions of dollars or the hundreds of thousands of dollars or the $600,000 a month in penalties that's going to be imposed on the city. All of that language was struck from the proposed order by the court. So if you read the order yourself, there are literally no fees, fines, or penalties looming, nothing hanging over the city's head. We are free and clear. We have room to breathe. We can adopt a housing element within the next year without any threat or concern of monetary punishment, essentially, from the state or from the court. Also, the Kennedy Commission, as an intervener, their relief was struck from the proposed order. That's an important note because a lot of people say, well, the Kennedy Commission is going to come in and make life difficult for the city and get a bunch of attorney's fees. Well, the Kennedy Commission's relief was struck from the order, so we'll see what happens on that. In addition, there's no RHNA mention in the court order. In other words, there's no state quota or state mandate mentioned in the order at all. So the 13,368 units, no mention of that in the court order. So there's no legislative outcome directed by the court. There's no particular result with regard to high-density housing or RHNA dictated by the court in the order. So those are all very positive things for the city of Huntington Beach as we move forward to work on a proposal and to bring it back to council over the course of the next year. And then finally, with regard to some of the concern over builders' remedy, and many people say, well, we're out of compliance, and so builders have an opportunity to come in and sidestep the city's zoning and build whatever they want wherever they want. Well, that's simply not true. We're a charter city. We've got decades of zoning law on the books as a charter city from our charter city authority. And so any builder that wants to come in and build in Huntington Beach by sidestepping our zoning may be met with a challenge. So that's up to city council if they want to fight builders in court, but that certainly is an option as well because we are a charter city, we do have our zoning, and just because state law says that builders are entitled to that remedy does not necessarily mean that a court is going to agree with them when it comes to builders' remedy against a charter city, especially like Huntington Beach. So overall, we're doing really, really well on the fight against high-density housing. I think the ball is in our court. We have room to breathe. There's no concern about financial penalties or any of those concerns about development, overdevelopment, sidestepping our zoning. We're in really, really good shape right now. So I'm quite pleased I'm pleased with the court order so far. We're going to continue to evaluate our legal strategy in that case. That case is ongoing. Another important update on the homeless front, as you know, the U.S. Supreme Court issued a very important decision last week on the Grants Pass case. For context, as you know, in 2018, the Ninth Circuit in the Martin v. Boise case basically said that local municipalities can't really enforce their anti-camping and anti-loitering laws because that kind of enforcement violates the Eighth Amendment, certainly if you don't have a homeless shelter as an alternative for the homeless. But the U.S. Supreme Court recently in the Grants Pass case said that's not true. Local enforcement can occur. Anti-camping laws are perfectly valid. They're legitimate. They do not violate the Eighth Amendment. And so Huntington Beach, with the support of the current council voting 4-3 to join the Grants Pass case, we were in the U.S. Supreme Court on that case before the U.S. Supreme Court. And if you read the Supreme Court decision in that case, it actually cites Huntington Beach not only as impacted by homelessness, but also affected by the Martin v. Boise case. So the Grants Pass case decision, the U.S. Supreme Court decision, very, very important to when it comes to enforcing on homeless. So our Huntington Beach Police Department has always done an amazing job. They've done a great job in spite of, at times, maybe having their hands tied behind their back. But they do a great job, and they're going to continue to do a great job. And this U.S. Supreme Court decision just gives them more freedom, more room to breathe, more ability to enforce. And so Huntington Beach is just in a great position right now, both on the fight against high-density housing with the recent update I just gave you, and then also on the U.S. Supreme Court decision. It's just great. Every Huntington Beach resident has every reason to be very, very positive and hopeful. We're going to continue fighting these important legal battles for you and join as many others as we can to protect Huntington Beach, keep us safe, keep us clean, and maintain the quality of life here. So these are two important updates of many. I just wanted to make sure that you had these two. It's a passion of mine to represent Huntington Beach in this way. We're going to keep fighting for you, and God bless Huntington Beach.